This deposition is how to prepare for a court conference. Three simple steps. We're going to begin with a discovery owed. Before there's a court conference, you want to check to see if there's any outstanding discovery. That's discovery that we owe to the defense. If you look through what we have as a pleading board that lists every document, every discovery demand, and next on the pleading board, next to each discovery demand would be the discovery response. So you just look through the pleading board and make sure that before the court conference, we've served all discovery. Because the last thing that we want to see at a court conference is I go there unprepared and the defense attorneys will be like, well, there's still outstanding discovery. They never served a discovery response. There's medical records that have not been provided, release authorizations that have not been provided. This is the most important thing. Go through the file before the court conference, ideally the day before the court conference, and alert the attorney, me, whether there is any discovery that we owe to the defense. Because if there is, you want to serve that discovery before the court conference, because I look bad if I go to a court conference and there's still outstanding discovery. So check the file to make sure that we've served all discovery responses that are due. That's the most important thing. Number two, check the file to see whether the defense owes discovery to us. It's a good opportunity at a court conference to raise the fact that the defense has not served meaningful discovery responses. And in New York, that could be a bill of particulars. It could be that they haven't served any discovery at all. They haven't allowed an original chart review for an inspection of the original medical records. Could be anything. But what you want to do is go through the file and look at the pleading board to see what demands have we served and what responses have we received? Is there anything that's outstanding from the defense? Because the court conference is a great opportunity to raise those issues with the court and say, Judge, there is still no meaningful discovery responses from the defense. And then the court will impose deadlines for the defense to respond to the outstanding discovery. So that's number two. Number three, before the court conference, there should be a preliminary scheduling order. And the preliminary scheduling order would have deadlines for all discovery, including paper discovery, depositions, the defense medical examination, which we call the DME. Never refer to that as the IME. We do not allow that in our office. But you want to check that because we want to make sure that we are complying with all of the discovery deadlines. If there's a discovery deadline that the depositions have to be completed by March 1st, you want to make sure that we get that done. If we are not able to get the discovery done within that time frame, then we would ask the court for an extension of the deadline before the deadline expires. So it's really important that we take the deadlines in the preliminary conference order seriously, that you know exactly what has been done, what deadlines are coming up. And if it looks like we're going to miss a deadline, we need to be proactive and we need to notify the court, get an extension. There could be good reasons for this, but if you don't take the deadlines in the preliminary court conference scheduling order seriously, the defense won't, the court won't, no one will. So that gives us sort of the outline of when everything needs to be done in the case. So pull up the preliminary scheduling order, email that to the attorney, me, so that I know what the deadlines are. Why is all of this really important? Because the court appreciates that when we are well prepared for a court conference, because most attorneys aren't. Most attorneys just wing it and they go in there, they send a young associate, they have no idea what's going on with the file. And if we are well prepared and we've spent time, number one, looking at what discovery is owed from the defense. Number two, what discovery does the plaintiff owe to the defense? And number three, what are the deadlines for discovery in the preliminary court conference scheduling order that need to be addressed? If we go in prepared and we have all of our ducks in a row and you get the attorney ready for the conference, then we look good and the court is impressed and the defense attorneys are fumbling around and they can't figure out because they haven't prepared at all. So those are three quick and easy tips for preparing for a court conference. Really important stuff. If you like the video, please subscribe to our YouTube channel. If you comment, I will reply. See you next time.